Hi, everybody. Welcome to our monthly webinar on Compliance 101. My name is Leah Kelly. I'm here with Shannon Wheeler, our General Counsel, and Elizabeth Sontag, our Product Manager. We host this webinar every month to give you a better sense of the different topics within compliance, show you what Tenstreet does to help you stay compliant, and let you know of any changes on the legal horizon, ultimately just help you avoid a lawsuit. So in our previous Compliance 101 webinars, we just focus on the big ideas like consumer reports or man in the box. But today we're going to dive in and focus strictly on adverse action. So this is our adverse action deep dive Compliance 101 webinar. So next month we'll do another deep dive. We're planning to. So if you guys have any ideas of things that you'd like to go into more deeply, then please do write in. You can write to leah@tenstreet.com, LEAH@tenstreet.com, or just respond to your GoToWebinar email that you've received. Okay, so you know this webinar will be recorded and sent to you within the next 24 hours. Also, feel free to submit your questions anytime throughout the webinar. You can do so using the text box under the question section in your panel, on your GoToWebinar panel. I'm going to be following those pretty closely, and we'll try to get to them right away, but if for some reason we're not able to, we'll get to them at the end. And that's all I've got, so Shannon, whenever you are ready.
Thank you, Leah. I appreciate it. Hi, everyone. Shannon Wheeler here. In sort of doing an evaluation of what other topics to dive into, we always get a lot of questions on adverse action. And so we decided to do a deep dive into adverse action and go through all of the steps and the reasons why we do this. So as typical for all of our webinars, we have our legal disclaimer here. What this is saying is that this information is offered for educational information only and does not constitute legal advice. While I am an attorney, I represent Tenstreet and am not a for-hire attorney for anyone else other than Tenstreet. However, we do want to be your partner in compliance, so we're trying to share the information that we know about with you. But we do recommend that you consult with your own qualified legal attorney on all of the issues, laws, and regulations that we talk about in this webinar. And so we expressly disclaim any warranties associated with this presentation or the information provided herein. And with that said, if you all do need an FCRA specific attorney or someone in the trucking industry, feel free to reach out to your account manager. We do have recommendations on great attorneys that know all of this information and help us stay compliant as well, that we can give you a reference to. Okay, so let's start out with the just a broad overview of the adverse action process. So adverse action comes into play when there is a consumer report, and when you are going to take adverse action against the consumer. So let's just talk about those topics real quick. Who is a consumer? That is the individual that you are running the report on. Typically, you have had the individual apply. They've either filled out an application or a lead app of some sort, and you have received a disclosure and authorization signed by the individual, and then you run what is called a consumer report. A consumer report is any report from a third party about an applicant, and it would be considered a consumer report. Typically, for our clients, that means an MVR, a SIDLIS, a background check, or criminal record check. Sometimes you might do a credit report, sometimes you might not, and also some employment verifications constitute consumer reports. So the reason why I put 2 asterisks next to employment verifications is if you are doing the employment verification directly to the previous employer, like you're sending it by fax to the other carrier, that would not be considered a consumer report. But if you're using, for example, Tenstreet through Exchange, that would be considered a consumer report. So if you're pulling any of these reports, MVR, SIDLIS, background checks, employment verifications through a third party, those are going to be considered consumer reports, which would instigate or initiate this adverse action process. Okay, so what constitutes adverse action? That is any negative change in the conditions of employment. So if, for example, you decide not to hire an applicant because of something in a consumer report, or if you decide to terminate an employee, demote an employee, or not promote an employee, all of these things would be considered adverse actions. There would be a negative change in the conditions of employment, and you would need to follow the adverse action process. So that's a broad overview of when the adverse action process comes into play, if it's a consumer, involving a consumer report, and the action you're going to take would be a negative change in the condition of employment. So what is the adverse action process? It is a two-letter notification process. So if you are intending to make a decision that would have an adverse effect on a prospective or a current employee based in whole or in part on a consumer report, you need to follow this process. The purpose is to allow the consumer to review their consumer report for accuracy and completeness, and if necessary, explain or refute any information that is in that consumer report. So the two-letter notification process starts with what we call, and we'll go through this, a pre-adverse action letter, and then you have a waiting period, and then you have the final adverse action letter. Now, I have on this slide something that I wanted to discuss in more depth in this deep dive, Compliance 101 into adverse action, because there's a one-letter notification process, which is a trucking-specific exception to the two-letter process. We actually get this question a lot from our clients. This exception exists, and you'll see that statute there, 15 U.S.C. Section 1681B, B3B. So if we have any other lawyers in the room, you'll know exactly what I'm talking to. Anybody else, I know this just looks like Greek, but that's where this exception exists in the statute. And what this letter, or what this specific exception says, is that if you're sending, if you're making the decision on an individual that falls under the Secretary of Transportation's regulations, then you can send just one adverse action letter within 3 days of taking the adverse action. However, we do not recommend that you follow this one-letter notification process simply because it does not comply with state and local jurisdictions. So there are several state and local jurisdictions that have these this adverse action process requirement as well. And as far as we can tell, none of the state and local jurisdictions have this trucking specific exception. So if you hire in any of those states, which I can't name all of them off the top of my head, but in California, Washington, New York City, those kinds of states are going to have additional laws that relate to consumer reports, and they have no exception for trucking like the FCRA does. So we do not recommend that you follow the one-letter notification process. The two-letter notification process is the best way to go. And you can follow the two-letter notification process and still be in compliance with the trucking-specific process. So that is the overview of what the adverse action process is. Why have an adverse action process? We get this question a lot. In fact, a number of companies, whether they're trucking companies or not, simply don't have an adverse action process, don't know about it, and don't follow it. And that is a very, very dangerous move to make. So that's why we're trying to get this information out there to let everybody know you got to have an adverse action process. Why? Because it's required. It's required by federal law. So that applies to anybody operating in the United States that pulls credit reports. Or I'm sorry, I say credit reports, that in broad terms is consumer reports. That's under the Fair Credit Reporting Act. It was passed in, I believe, 1930. And it's been updated a few times over the years, but essentially the adverse action process is required by federal law. Anybody hiring within the United States that pulls a consumer report has to follow the adverse action process. It's also required by many state and local jurisdictions that you have an adverse action process. And the biggest thing, so, okay, it's required by law, but what are the risks? Well, the risks are pretty big. A single violation is it can include a fine of up to $1,000 over the last 2 years. So then if you add up all the times that you haven't sent an adverse action letter to every applicant over the last 2 years, it'd be $1,000 per violation, which can add up very, very, very quickly, especially for trucking companies when you have lots of applicants that you process. The other thing is that we saw an uptick in FCRA litigation in 2018. I think by April of 2018, they could tell that there was a 20 to 30% increase in FCRA litigation cases. However, since those were just filed in 2018, we don't have a lot of settlements. We don't have a lot of information on what's happening with those cases yet, just because those quite frankly, take time to go through the system before the information gets out there about any sort of settlement. So, but what I can point to are settlements that we know that happened in 2017. So in June of 2017, there was a company that had several FCRA violations, one of which included the failure to send a pre-adverse action notice. And that company settled a multi-million-dollar settlement at $7.5 million. That's just a huge amount of money for major FCRA violations, which included not following the adverse action process. Then we know of a case specific to the adverse action process that settled for $2.7 million. So those are just huge settlements. It could do a lot of damage to your business to have an FCRA lawsuit for failure to send out and follow this adverse action process. In August of 2018, we've seen a case where the Seventh Circuit found a willful violation of the FCRA against an employer who failed to follow the adverse action process. Essentially, the court said because the adverse action process is statutorily required, any failure to send out the adverse action letters constitutes a willful violation. And what that does is that increases or ups the damages that a plaintiff can get in a case and makes it a lot more costly. And then the last thing that that I want to point out here, but also we pointed it out before, and that is that we have seen test plaintiffs come in and apply to, let's say 60 carriers. And then the ones that don't send out an adverse action process or don't have proper disclosures and authorizations will then file suit. So these are test plaintiffs that have found it easier to file lawsuits versus get a real job. And last year alone, we found that one test plaintiff filed suit against 17 carriers. So these FCRA violations are out there, and the cases are filed by, I think it's like fewer than 30 plaintiffs. I think 30% of the cases in 2018 were filed by less than 10 plaintiffs. And so what's happening is these test plaintiffs are just going out there and trying to find an easy way to make money. Okay, so let's go step by step on what should happen with an adverse action process. Step one, determine whether you have the intent to take adverse action based on a consumer report. If you do, if you say, and by the way, I recommend that you err on the side of caution here, and we'll talk about that in a minute. But if you do determine you're going to take adverse action based on information in a consumer report, then you want to follow step two, which is send out a pre-adverse action letter. After that, you'll follow step three, which is wait a prescribed period of time. And as we'll talk about, we recommend 10 business days to comply with all federal and state jurisdictions. Then you'll follow step four, which is to send out a final adverse action letter. Okay, so let's dive into step one. The statutory language is if you intend to make a decision in whole or in part on a consumer report, then you must follow this process. So the best practice is just to send a letter anytime there's adverse information in a consumer report that could influence your decision. Essentially, you want to follow the process out of an abundance of caution, because you can't see what you've seen in the consumer report. And likely, if you've seen it and it's negative, it's influenced your decision. This can also come up in ways that you aren't thinking about. So for example, if an applicant has falsified their employment application, then and you can tell that they falsified it based on a consumer report, you're going to want to follow the adverse action process. if they have something incorrect about their employment history, or if they stated something incorrect to you about their employment history, but you've gotten the employment history through a third-party vendor, likely you're taking adverse action based in part on that consumer report, and you're going to want to follow this process out of an abundance of caution. Same thing with accident information and criminal charges. If you've seen those things on a consumer report and they've influenced your decision, follow this process out of an abundance of caution. Okay, so step 2, the pre-adverse action letter. What does this need to be? It's a letter that goes out to the candidate. It can go by email. It can also go by snail mail. You can send it electronically, and it informs the individual that you have the intent to take adverse action based on the consumer report. The key here is that you haven't actually made the decision yet, is that you just are considering making this decision. So what you also want to have in the letter is that you're listing the specific criminal charge or information relating to the decision. You don't always have to do this, but it is required in some states. And that also only applies to criminal charges. So if you're making the decision based on something that you found in an MVR, you don't need to list what you found in the MVR. But for example, if you're making the decision based on, some other criminal charge, some states do require that you have that. You want to list your consumer reporting agencies and their contact information in the pre-adverse action letter. And then key here is that you want to enclose a copy of the consumer report that the decision may be based on. So the cases under adverse action and the cases under the FCRA really come down on, did the consumer get the information that they needed? So a lot of times what happens is you pull these consumer reports and the individuals just don't know what's in those consumer reports. They don't know what's in their background checks. And so the FCRA primary purpose really is to provide the consumer with that information. And so when these cases come down, oftentimes the decisions are made and turn on whether the consumer got the information or not. So you definitely want to make sure you enclose a copy of the consumer report that the decision might be based on, enclose a copy of the FCRA Summary of Rights, and enclose any required state or local notices. We'll cover these in a little bit more detail later on in this webinar, but Los Angeles and New York City have their own forms that are required. So if you are taking adverse action against an individual that's in one of those jurisdictions, you want to make sure you send out those forms. If you don't hire in either LA or New York City, then you won't need the form, but if you do, you'll need that form. But we'll cover that here in just a minute, a little bit more depth. So step 3. Okay, the waiting period. We get a lot of questions about how long to wait after you send the pre-adverse action before you send the final adverse action letter. And so the entire point of the pre-adverse action letter is to allow the consumer time to dispute the information that's in their consumer report. Because oftentimes consumer reports just have it wrong. They have the wrong individual, they've reported the wrong information, or they've reported it wrong, or it's so old it should have not still be on there, things along those lines. So the FCRA requires that an employer wait, quote, a reasonable amount of time. That is sort of, what is a reasonable amount of time? That's up to whatever, up to interpretation. Courts have said that a reasonable amount of time is 5 days. However, state and local jurisdictions have enacted statutes that make that even longer. There's one state that requires 7 days, and then there is Philadelphia, which requires 10 days. And then there is California, it's either California or LA, that says you have to wait 5 days, and then if the consumer disputes it, you have to wait 5 more days. So essentially, you need to wait 5 business days to comply with all federal, state, and local jurisdictions before you make a final decision and send out the final adverse action. The point of that waiting period is to allow the individual time to dispute the completeness or accuracy of the information in that consumer report. Okay, there's a little bit of what happens if they do dispute it. So if we wait 10 business days, let's say on the 9th day, the individual calls in, disputes the accuracy or completeness of the report, what happens then? Well, what happens then is that they need to dispute it with the consumer reporting agency that reported the information. And the consumer reporting agency has 30 days to conduct a reinvestigation. If the individual provides additional information within that 30 days, it could extend that deadline out for 15 days. So really, the best policy would be to hold that position open for that period of time, see if the consumer reporting agency does anything with that time period, whether they take off the particular criminal charge or take off any information that would change basically your decision. And then you want to make sure and follow an individualized assessment process that considers and assesses the information provided by the applicant as well as the information provided in dispute to the consumer reporting agency.
Okay, thanks. I've got a question here, and you may have answered it for this person, but I'm going to go ahead and ask it.
Sure.
What happens when we send the adverse action letter late?
So, great question, and I don't want to provide legal advice here. However, I will say sending the letter at any point in time is better than not sending it at all. So the point of the letter is to provide the consumer with the information. And most of what we see litigation-wise under the FCRA is that the consumer just didn't have the information. So even if you send it late, even if it's delayed, at least the consumer does get the information. So it's better to send it late than never, but you know, as to the specifics of how late and where it is, really recommend you talk with an FCRA lawyer on that one, and who can really dig in and talk about the specific circumstances of that particular letter process. You want me to keep going with the final adverse action letter?
Go ahead and keep going with step 4.
Awesome.
Yeah, 4.
Okay, so after you've
got a couple more, but we'll hold off. Yeah.
Okay, great. Feel free to chime in after this step. So after you wait 10 business days, step 4 is you send the final adverse action letter. So if there's no dispute during the waiting period, send out this letter. What does it say? It says, we decided to not hire you, or whatever the adverse action is, terminate you, so on and so forth, based on the information in CRAs. And make sure you enclose a list of your consumer reporting agencies and their contact information. Also, in this letter, you want to state that the consumer reporting agency is not the decision maker and cannot explain the reason for the decision. You also want to enclose the FCRA Summary of Rights and any required state or local notices again. You also need to inform the individual of their right to obtain a free copy of their consumer report and inform the individual of their right to dispute the accuracy of the completeness of their record. So that is the final step in the adverse action letter process. It can also go out electronically or by snail mail.
Okay, thanks. So to follow up the last question, if the candidate does dispute the accuracy of the report and the CRA confirms the modifications have been made, but then they still disqualify the candidate, do they have to send out a secondary set of pre and post adverse action letters, or?
Okay, so let me make sure I understand the question correctly. The question is, if they dispute something that's in the consumer report, and it turns out that it was accurate,
or even if it wasn't and they made modifications to it and the modified report still would
disqualify them,
do they need to send out a second set? Yeah.
That's a very good question, and it would actually depend sort of on the specific facts and circumstances of each case. So each case is really determined on a case-by-case basis, and I would say if probably the best practice would be, yes, to go ahead and send out a pre again. However, if you send out the pre and they dispute the accuracy of the information in it, but it comes back the same, like the consumer reporting agency does a reinvestigation and they say, no, we determined that this information is accurate, then you could just send out a final in that circumstance. But if the information changes somehow, or if you're making your decision based on something else or another consumer report, then it might be a good idea to start over again, but it would really just depend case-by-case basis. You probably would want to talk to an attorney on that one.
Yeah, that'd be a good one for an attorney, I think, because it sounds like they're wondering, like, how long do we have to continue in this cycle? You know, how long can they keep disputing and they have to leave the position open? And
that can be very difficult
Yeah.
to determine. I understand that that's a sticky situation, and yes, in that case, I would recommend talking with an attorney.
Okay, thanks. So here's another one. How do we handle this if the applicant has to go through insurance approval process first and the applicant is denied?
Okay, so do I understand that question? That's like insurance is not approving that particular driver for something that's in their report. If that is the case, if the insurance, it depends on really why insurance is not approving them, but if they're not approving them because of like something in an MVR or a SIDLIS or something that is in a consumer report, then yes, you would want to follow this process. If it's just insurance making the decision, it doesn't have anything to do with the consumer report, then you don't need to follow this process. This process only gets involved if you're making a decision based on a consumer information in a consumer report.
Okay. Let's see. There's a whole bunch. We're getting a lot of questions in here, which is awesome. I'm so glad that people are engaged and have lots of questions about this topic. So let's just start, just to make sure that she understands, or he understands, if the MVR information is what we are making our hiring determinations on, we don't need to send the notice?
No, that is not correct. If you are making a decision based on information in an MVR, the MVR is considered a consumer report, and you will want to follow the adverse action process. I'm going to make that real clear. That is one of the big things in our industry, because under the FMCSA and all of the DOT regulations, you have to, as a trucking industry in hiring a driver, you have to pull these reports. The FCRA comes into play a whole lot with trucking companies. And so if you pull an MVR, which almost all of our clients do, and almost all trucking companies do when they're hiring a driver, that is considered a consumer report. If you're making an adverse decision against the candidate based on something in that MVR, you're going to want to follow this process.
Good deal. Okay, so thanks for clearing that up, making that really clear. Sometimes background checks take longer than the usual few days, and so they'll go ahead and start a driver as with the information that they have. So after, are they able to determine that terminate the driver after the fact the background was not passed?
Absolutely. If you have followed through and hired the person, but then you figure out that there's something in the background report that would disqualify the driver, you can terminate them for that reason. I'm assuming there's not any other issues. But if you decide to terminate them based on what's in that report, you would still need to follow this process. You would need to send the pre-adverse action letter, make sure that they don't dispute any information in it, and then wait the prescribed period of time. And then if they don't dispute it, send out that final adverse action letter, even if that means you're terminating the employee that you've already hired.
Okay, we've been told that the adverse action letter has to be sent by mail only if we disqualify for the PSP report. But can that also be sent out electronically? Do you know anything about that?
Okay, so let me make sure I'm asking the question, or I'm understanding the question correctly, that they are disqualifying a candidate based on the PSP report, and they think it needs to go out by mail as well.
Only.
By mail only. You know, that's a really good question. I haven't had that one come up before, but it's my understanding that you can send it electronically. We have other clients I know that do send it electronically, and I've never seen anything that specifically says you can't. So I do believe you can send it electronically.
Okay, does the adverse action letter automatically go out at 10 days, or does someone within the company have to initiate it or trigger it?
Well, if you're talking about what happens in Tenstreet, I'll let Elizabeth talk about that.
Yep. So it can go automatically if you're
using our product.
Yes, you can set up automations around it, or you can run a process that says, hey, I just need to send the adverse action letter. As long as the client has provided an email address, it will go out automatically. If they do not, or they fall in one of the jurisdictions that have additional information, then you'll probably have to print it out and mail it from there. But we have some tools and a couple of processes that will help you with that to manage those as well. So there's a couple of different options for that.
Yeah, we'll be talking more, or Elizabeth will be talking a little bit more about that later, but that's a configuration setting within Tenstreet's Adverse Action Set service where you can set the number of days and it will automatically just go out. Okay.
We do have a couple of sample letters on the next slide that's not real big, and you can't, you might not be able to read word for word here what's in all of those, but these are our sample letters that we, of course, clients in Tenstreet can have and set up their own letters, but these are the sample letters that we can provide to clients that they can modify with their information. And so the first one, which is probably really hard for you to read the fine print, is the pre-adverse action letter, and it has a place for you to fill in your company letterhead, your name, has the information that we talked about specific to the pre-adverse action letter, and then you would just insert your consumer reporting agencies, and then make sure you send out all of the required attachments, like the particular background reports, the FCRA Summary of Rights. We also would add in here if there were any of the specific criminal charge that needed to be added, we would add it into the letter. And then there would be the second and final adverse action letter. Same thing, has all the required information that needs to be enclosed, and you would just can modify this to the language that is specific to your company. Okay, and on the next slide, I just wanted to dive in a little bit here to the state and local notices. These are the required state and local jurisdictions that have additional requirements. So New York has an Article 23A notice that also needs to go out. New York City has a New York City Fair Chance notice that actually has to be completed. It's their own particular form. New Jersey has a Summary of Rights that needs to go out. California has one. In addition, within California, San Francisco and Los Angeles have individual requirements. So these are both notices, and in LA, it's a required form that you have to fill out. Washington has a Summary of Rights, and then Massachusetts has a criminal record information policy and DCJIS information. So if you hire out of any of these state or local jurisdictions, you are going to want to have these state and local notices that go with your pre-adverse action and adverse action letter. The trucking industry, because it's so unique in that it's kind of unclear where the job is because they're over the road and driving all over. We, out of an abundance of caution, recommend sending out these state and local notices if the applicant is residing in one of these locations, or if the job is in one of these locations. I'm sorry, and by job I mean if the primary location of the carrier's business is in one of these locations. And if you have multiple terminals, that you have a terminal that's in one of these local jurisdictions that they are going to be reporting to, then you're going to want to include these state and local notices. It's just the FCRA was not designed specific for the trucking industry, so it's just sort of really unclear where the job is when you're looking at and doing an evaluation of candidates in the trucking industry. So those are the things that we, out of an abundance of caution, use, are where the candidate resides and where the business is located.
Okay, I've got a couple more questions I'm going to go ahead and shoot in here since there's quite a few.
Great.
You wanted to keep going?
No, that's fine.
But there's still some hanging on. So we had employment history reports all the time. The dates are different than what the applicant put on the application. So should we go ahead and send a letter at that time?
If you are going to take adverse action against the individual on that basis, on the basis that the dates are different, then yes, you should send out a pre-adverse action notice and follow the process. However, if you just are going to clarify with the driver or fix those dates, then you can fix them. But if you're making an adverse decision based on the change in dates, then yes, I would recommend you send it.
Good deal. Okay. Can a candidate still state you didn't hire them because of their bad CRA, even if another person was just a better fit or had more experience? You know, how do you get around that if somebody's...
That is a really great question, and that is why I recommend, out of an abundance of caution, if there is anything negative in a consumer report that could have affected your decision to go with another candidate, it's probably best to go ahead and send these out. It doesn't hurt to send it, but it certainly hurts to not send it. So I would just follow an abundance of caution standard based on the broadness of the FCRA law, and send it if you think it could come into play.
Good. Okay, here's a good one. If someone calls in and wants to know about their issue or why they're not being hired, or why did they get this letter, does the recruiter talk to them, or who at the company should talk to this person?
That is a really great question.
This is a good one.
And it actually plays into the next slide. Elizabeth, if you don't mind, it's individualized assessment. And so really what you don't want to do is you want them to get the letter. You don't want to talk to them over the phone. There have been several cases where a recruiter has said to the individual before they got a pre-adverse action notice, oh, we're not hiring you because of your background check, or oh, we're not hiring you because of your MVR. That's not good. Cases have come down very negatively against that. And so my recommendation would be, of course, in working with an FCRA attorney about your own individualized process, as I would communicate to the individual, we have not made a final decision yet, but you will get a letter via email or mail or however you send them, which further describes the process, and then send out the pre-adverse action notice. And then that informs the candidate of everything that they need to know, and that is everything that's in writing, and you haven't said anything over the phone that might be negative. So the individualized assessment, how this plays into it is that you don't want to have a blanket policy of we disqualify everyone who has a criminal record, or we disqualify everyone who has ever had X, Y, and Z on their reports. And because we want to conduct an individualized assessment based on what the job is versus what the criminal charge or the information in the report is. And so you look at the specific job functions and the business needs. Individualized assessment says, is it job related and consistent with business necessity? And so the case law here is that you want to train and hire your staff to consider the nature and gravity of the offense or the conduct, the amount of time that has passed since the particular conduct occurred, and the nature of the job. And then you want to allow the candidate the ability to explain mitigating circumstances. And so if you've just disqualified them over the phone before they've ever received a pre-adverse action letter, you have not allowed the candidate to explain any of those mitigation circumstances. And then you also have communicated to the candidate that you've made a final decision versus allowing them to see the pre-adverse action notice, see what's in the consumer report, and dispute any of that information before making a final decision. So additional considerations that you want to make when you're doing an individualized assessment is to include facts and consider facts and circumstances around the offense, the number of offenses, the individual's age at the time of conviction, any additional employment they have had in between the offense and their current application, any length of time in employment history, rehabilitation efforts, education and training, and other references. So these factors that I have in this slide are really directly from the case law and directly from cases that have said that this individualized assessment needs to happen under these bases. So yes, highly recommend that you send out the pre-adverse action letter prior to having a phone call with the individual. And if you do happen to have a phone call with the individual, the communication really should be along the lines of, you're going to get a letter which further explains the process, or your application for employment is still pending, you should get something that will explain the process from here. All of those are very appropriate things to say, but I would not have a conversation with the individual prior to sending out the pre-adverse action letter, which says, no, we've decided not to hire you because of something in your background check.
Thank you. Okay, so how does one release allow them to continue to run the MVR and background checks throughout their employment, or how often do they need to get a new release if not?
That's a very good question. That's a very good question. I'm gonna recommend that you talk to your lawyer about that one. I just as non-legal advice, I believe that will allow you to continue to obtain, because I know you probably do MVR monitoring, but that's really going to depend on how long you have them on file and when it was signed and what specifically is stated within your disclosure and authorization. So best practice, talk to a lawyer about your specific disclosure and authorization and process, and whether or not that will allow you to continue to pull them.
Okay, great.
All right, Elizabeth, if you would, next slide. So I wanted to talk specifically about the adverse action process in the trucking industry. Many of you have probably heard that there's a verbal exception, and what this says is that you can provide the pre-adverse action notice and the adverse action notice orally to the applicant. It's not really recommended. First of all, you would have to spend the time, energy, and effort to read all of the information off to the candidate over the phone, but then also written letters just provide better evidence in any subsequent case that the applicant, could say, oh, well, they didn't tell me this, or you'd really be relying on the applicant in any case that was brought to admit that the proper notice was given to them over the phone. So this exception came about because the trucking industry back in the 1930s, actually, I think it was after that. I'm not as familiar with every single amendment to the FCRA as some other people are, but it came about because the trucking industry lobbied heavily for this verbal exception because they recognized that truckers were out on the road and weren't getting notices by mail, or it was really hard to provide something in writing to the particular applicant. And so they created this exception knowing that that candidates in the trucking industry often did business over the phone. However, the reason for this exception is less applicable today because we have smartphones, we have tablets, we have the internet, and it's so easy to just send a notice by email. Everybody has email. A lot of business, in particular between the candidates and the trucking companies, is conducted electronically, and the FCRA allows for that. So really the reason for the verbal exception is less applicable today, and it's just a lot better evidence to have a written letter that's been sent. If you do practice the verbal exception, you need to have contemporaneous evidence that there is a program and training in place, that all notices are provided, and that it's followed 100% each and every time. And that's just very hard to prove. So that's why the verbal exception isn't recommended. Another exception in the in the trucking industry is specific to the adverse action process, and that's the one letter process that I described earlier. And again, that's not recommended because state and local laws don't provide for the trucking exception. So best policy is to do a 2-letter process sent out to the candidate. Okay, let's move on to some adverse action process gotchas. So some traps that we would recommend our clients be wary of and to watch out for is not listing or updating your consumer reporting agency information within your adverse action letters. So you might already have an adverse action process in place. Go back and look at those letters if you haven't set them up in the last year or so. Make sure that the contact information for your consumer reporting agencies is up to date, and make sure that you have every single one of them listed. If you do your employment verifications through Tenstreet Exchange, make sure you list Tenstreet as the consumer reporting agency on those adverse action letters. Make sure you don't have a blanket policy or matrix that automatically excludes any driver that has a criminal history. You want to conduct that individualized assessment. Be very wary of verbal statements like we've talked about. Make sure that you don't disqualify the applicant prior to sending the pre-adverse action letter. Also watch your third-party recruiters. Oftentimes third-party recruiters don't know about verbal statements, and they will communicate verbally with the driver saying, nope, you've been disqualified prior to the pre-adverse action letter ever going out. You don't want that to happen. Like we've talked about, we don't recommend you rely on the one-letter process. And then make sure that you so we've seen a lot of companies get in trouble because they would have see something in a consumer report, set the applicant to not qualified, and then the pre-adverse action letter would go out, and it would be like a tag of not qualified or ineligible, and you'd rate them as such, and then you'd send out the pre-adverse action letter, and then the applicant would call in and say, hey, that's not me. The consumer report you have is somebody else. I promised that wasn't me. With that criminal charge, and you say, well, we've already not qualified you, and you don't have a process in place to change that status and reevaluate the candidate. So make sure you have one of those processes in place. And then also not using the adverse action process for your MVR monitoring. So if you pull MVRs every year, like you are required to for the DOT rules, make sure that if you see something pop up in that MVR that you're gonna terminate the individual for, that you follow the adverse action process and allow them to dispute that information before you make a final decision. Okay, so that is all that I have for you on the educational side of the adverse action process. I can answer questions, or we can allow, I think Elizabeth is gonna take you through how the adverse action process works in Tenstreet.
I do have one quick one.
Sure.
So if we're using, and actually, you know what, I'm going to go ahead and let Elizabeth talk about this first because it is about the Tenstreet Adverse Action Service, so she's going to probably hit on it.
Okay, great.
But we'll come back because there's still a few others.
Okay, let me just switch over. Okay, so in the dashboard, you're going to have the options to run a process, or you can have some automation around the adverse action process. And what that's going to do is that's going to go through your setup for how you have your adverse action process set up. Companies have a lot of flexibility in how they set it up. You can choose the different date ranges, as kind of Shannon has said. You can also put a little buffer on it, like an hour is what we like to do, so that if you accidentally run a process or something along those lines, you can always come in here and cancel a letter if you need to. So what you're going to do is you're going to go to Tools at the top, and then you're going to select the option of Consumer Letters, and that's going to load your Consumer Letters tool. You can put dates in, you can search by last name, you can also search by the type of the letter, or you can leave them blank and search and it will pull back everything. And so what we have here is we have Carlo that's waiting on a pre-adverse, and he has an error. And an error is meaning that there were no documents able to be attached to the pre-adverse action letter. So in other words, you may have scheduled a process for Carlo that you're not hiring him, but you never ordered any kind of background checks that are within the system to attach to the letter. So it's going to error out, and it's going to say, oh, wait, we can't send a letter because we don't see any documents to attach to the letter. So it's going to give you an error. We also have some options here that are for post and pre that are ready to mail. And in these scenarios, it could be that Madalena did not give you an email address, or Madalena lives in one of those places that you have to enter in some additional information to be able to mail that out to her. So here's where you can see all of your letters. You can also select all of these different options, and it loads based on however you have selected. It gives you the time for the next action. So this is letting us know that the post letter is going to go out. It went out today at 2:06 for Emily, and then it's going to go out for Joe. It went out on 2/6 at 9:56 a.m. So you can see the different options here. When you have one that's ready to mail, you can just click on the person. You can open them up in the subject view. It gives you the documents, all of the documents for the subject that you see. And then you can also open up the cover letter, and that will also open up so that you can print those items, and then you can stuff them in an envelope and you can mail those to Madalena. So the tool is pretty easy to use. There are some different things that you'll also get. I think it's either weekly or monthly, and I apologize, I'm not 100% sure. It will send you an email, the primary an email. So if you have anything that's waiting to be mailed or ready to be mailed, you'll get a little reminder that you need to come in. But our suggestion would be that you kind of come in here once a day, maybe at the end of the day, and see who's ready to be mailed, and follow the process of printing those out and getting those ready to be mailed out for the next day. But there are some other options for you. One thing that's a great tool as well is if you go to your tools, you can go to your Compliance Center. And the Compliance Center has a whole section right here on adverse action. And so at the top, you've got letters waiting to be mailed. So just like the email, it tells you that there's 80 letters that are waiting to be mailed. So then you could come back and you could go to your tool and you could search for everybody that is in a ready to mail status. So I'm going to take out all the others, and I just want to see ready to mail. And then it's going to refresh, and it's going to show me all of those 80 subjects that are ready to mail. So then I could go in and print each one of those and move forward. So I'm going to go back to the Compliance Center. And the next one is letters emailed. And this card is going to show you how many adverse action letters. Oh, I'm sorry. It's going to show you, it's the number, and it indicates how many adverse action letters have been emailed to subjects over the last 90-day period. So this is a graph, and it actually graphs 90 days. So the first 30 were 0, the second 30 were 0, and then the last 90 were 1. So that's not a very good example. Yours letters will be better, but the graph will actually show you the numbers, and then it will give you a number to the side as well. And then in your adverse action settings, you can actually click on this, and it will tell you the file type options that are included in your adverse action letters, the return email address, the exchange fax message, and then also what your post and pre-adverse action letters look like. So you can see all of the data for your adverse action and how it's set up within this card. So you can click here to see the information.
If you don't have the adverse action product with us, that card, I believe, says NA.
Yes.
So
It says not implemented, I believe.
not implemented?
Yeah,
Okay.
I think that was fixed, so.
But if you do have it with us, you can click in and see all of those things.
And so the question was, is if they're using this AA services with Tenstreet and they're sent out electronically, how is the client able to submit to the candidate the specific reason as to why they're not qualified if that person doesn't live in a jurisdiction that has a local notice document or otherwise? Is there a way, if they get a whole lot of consumer reports and they're not sure which one was the one, how do they indicate which one was the one that they made the?
Well, you don't, and unless it's required by jurisdiction to identify the particular criminal record, you don't have to identify what the specific information was unless you just want to. If you're not making a decision, I wouldn't identify it unless you just really want to, or unless you're required to by state. So I do know that, and Elizabeth can speak to this a little bit more, within our system, if the applicant lives in one of the jurisdictions that requires that you identify the particular criminal charge, we will have a pop-up box.
That's correct.
And then you can type in the particular criminal charge that you're relying on, and it will automatically add that to the pre-adverse action letter. However, I wouldn't recommend, if you don't have to, if you're not required by one of those jurisdictions, I wouldn't necessarily identify it. If the applicant calls in and says, hey, I want to know what specifically it was, you can tell them and see if they dispute it, but you're not required to.
Okay, good, thanks. About an internal background check or an internal investigation, they've been told that if they're internal, that they don't have to actually send pre or post adverse action letters if they're not getting it from a agency, for example, or a third party.
So yeah, I guess I don't understand what the internal means, but what the evaluation that would need to happen is whether that information that you're disqualifying the individual on is based on a consumer report. So the only time you need to send out an adverse action letter is if you're making the adverse action based on a consumer report. So I don't know what you mean by internal, but if you haven't gotten the information from a third party or from a consumer reporting agency and it's not on a consumer report, you don't have to follow the adverse action process.
Okay, great. All righty. And I think there's a few people asking for copies of the letters that we have in the PowerPoint. And
certainly, if you have the adverse action process tool with us, we are happy to provide those to you. Just reach out to your account manager, and yeah, we can provide those to you.
okay, great. So we'll send those out as well when we send out probably not the same email. You'll get it in a separate email than you do the recording of this webinar, but we'll send them out.
Other questions that I have run across and often gotten in this adverse action process is whether the information in the letters and the reports is confidential. And so yes, quite often is, but it's confidential in the sense that you can share it with the consumer themselves, but should not be shared with anyone else.
I've got one. Is it a good idea or a bad idea to have the requirements or the disqualifying events just listed out on your website?
That is a very good question. I know that oftentimes companies do that, and that sort of helps to tell an applicant whether or not they can or would or would not be qualified. And it really just depends on what those things say. So it's not necessarily a bad idea, but you might, it really is going to determine what those things say on whether it's a good idea or a bad idea. So you might have those particular items looked over by an attorney. You certainly wouldn't want to say within that, we don't hire anybody with a criminal background, period. That would be a very difficult position to defend in a case for individualized assessment. So you can certainly have those guidelines. You just want to be very careful about what they say.
Okay, thanks. We are pretty much caught up on questions.
All right, everybody, thank you so much. And if you have any other questions that come up, please feel free to email us at sales@tenstreet.com or call us. Also, feel free to contact your account manager. We appreciate you joining us today on this deep dive into adverse action.
Yep, thanks so much for joining us, everybody. We appreciate your time.
Bye-bye.
Bye-bye.